Court of Appeals, Division 1 is now in session.
Please be seated. Court now calls case number CV140776, Mining Investment Group LLC versus Kaylin Price. This is the time set for oral argument. Good morning, counsel. Each side has 20 minutes to present their argument. The appellant will go first. Counsel for the appellant, Mr. Littler?
Yes, Your Honor.
All right. Mr. Littler, if you want to set aside some time for rebuttal, just let us know. Both of you have a clock up there to keep track of your time, so that'll assist you. The proceedings are being recorded. They're audio and video recorded, so they'll be uploaded to our website a couple days after today's hearing. Keep that in mind. People will be able to view this on the internet. We've read everything in the case. If you would, for our record, our audio record, just announce who you are and which party you represent so we have a record of that. And with that said, Mr. Littler, your argument.
Thank you, Your Honor. Good morning. Thomas Littler and Ellen Davis, representing the appellant, MIG. May it please the court? I will set aside some time. There's also a cross appeal that I may have to deal with, so I probably will set aside about half my time, but let's see how well it goes and what kind of questions I have to answer and that kind of thing. I'd like to focus on the trial court's ruling on the order granting the defendant's motion for new trial. There were the basis for it was lack of adequate findings that were timely requested, and that the request was granted by the court and never waived by the defendant. That's the key to the ruling of the court on the motion for new trial, which is at index number 243. I'd like to focus first, because I think it's dispositive of the appeal, on the waiver issue, because I think that's extremely important here as to the behavior of the defendant here and how we got to where we are today. It is true that Ms. Price, representing herself, did file a motion for findings of fact, and that's at index number 63. And that was on April 12th, 2011. And it was in the context of asking for findings of fact, not for the trial, because the trial wasn't until September of 2012, so it's a ways down the road. It was in the context of for summary judgment motion. And Judge Jones recognized that. She also, at index 73, she also filed proposed findings of fact. Judge Jones recognized the difference with what she was doing in his ruling, under advisement ruling at index number 120. And what he said in this context is important, and it's important to the waiver argument. What he said was that the motion for findings is denied, and I'm paraphrasing here. It's denied as to the summary judgment motion, which makes sense. You typically don't, in a summary judgment motion, get findings of fact. But then he says, and I quote, "To the extent defendant wishes to have findings of fact and conclusions of law made at the conclusion of the trial of this matter, defendant's motion is granted." So Judge Jones did say, if you want them, I'll give them to you at the end of the trial. Good enough. I mean, trial goes about over a year later, and the plaintiff, Mining Investment Group, wins. Ms. Price loses. And then what's interesting here is how Ms. Price reacts, because at index 195, she files on December 5th, 2012, an objection to the lodging of the judgment. And what the judgment did, and it's part of the appendix, what the judgment did is it pretty much paraphrased the minute entry from Judge Jones, saying this is what I find, and this is the ruling. Well, Ms. Price objected to it, and nowhere in this objection at index 195 does she talk about the findings of fact or the request for the findings of fact, or that the judge offered them if she still wanted them. In fact, at paragraph 8 on page 3, she objects that, and I quote, "All plaintiff had to do was copy the court's under advisement ruling in the form of an entitled judgment exactly without attempting to prejudice defendant K. Price in any way." A proper judgment would then clarify the record for motion to reconsider and notice of appeal and clarify the appeal. So what she's saying here, she doesn't mention at all the findings, or that she wants findings, or that she requests findings.
So even though she did, as you acknowledged, request findings a year earlier, and the court granted that findings would be made at the time of the trial or at the end of the trial,
If she wanted them.
she was entitled to them at that point, but your argument is, your position is that she needed to remind the judge of that.
Yes, but there's more to it, Your Honor, because there's a second objection to the form of judgment. What happened was, I think the judge instructed the plaintiff's counsel to make a few changes to the judgment. So then she files a second form of judgment. And this is where it takes it from waiver to really invited error. And that's a little bit different concept, but it's...
Let me,
sorry.
Counsel,
yes,
let me,
Judge Gould.
let me kind of move you into a different construct on this, okay? I'm not sure that objecting to the form of a judgment really deals with sufficiency of findings under Rule 52. Have you looked at Rule 52B at all?
I'm sure I have.
Because the parties didn't really talk about this a lot in their motions, or in their briefs, but Rule 52 specifically allows a party to make a motion requesting the court to amend its findings or make additional findings within 15 days after entry of judgment. It expressly states that. So it preserves this right after the judgment has been entered within 15 days to make a motion to amend or supplement the findings. And Rule 52B further provides the motion may be made with a motion for new trial pursuant to Rule 59. So I looked at the motion for new trial, assuming that it's timely. I know there's an argument that it's not timely. But I looked at the motion for new trial, and that's Record 216. And at pages 20 through 22, Ms. Price challenges the sufficiency of the findings.
Right.
So where's the waiver?
Well, my point is the waiver has happened by that time. Because in the second objection to judgment, she objects to the form of judgment, saying it doesn't have, it has findings of fact, and they shouldn't be in there.
But should findings of fact be in the judgment?
Well, if they're not in the judgment, she could have said to Judge Jones, I requested and you ordered findings of fact. She didn't say anything. In fact, she's taking an alternative position at that point.
I understand,
Yeah.
but I mean, how does that waive her right under Rule 52B to challenge the sufficiency of the findings after the judgment's entered? I mean, she's filed these motions saying you shouldn't put findings in the judgment. And I kind of tend to agree. I mean, I don't know about putting all these findings in a judgment. She loses.
Right.
The judge enters a judgment. I think it's on February 25th. And then there's bankruptcy proceedings and so forth. But assuming that the motion for new trial is timely, I'm just not understanding why it's a waiver if she has this express right under Rule 52 post-judgment to challenge the findings that the court made.
Well, it's an interesting tying of the two concepts of the delay.
Because the purpose of the findings of fact and conclusions of law is for appeal, right?
Correct.
And so you have a judgment, and then post-judgment, you want findings, specific findings. You want to follow up on your Rule 52A request
Right.
so that you can frame the issues for appeal.
Post-ruling.
Post-ruling.
Right.
Yes, Your Honor. That's it. We think that she waived it when she invited Judge Jones to remove, or asked him to remove the findings from the judgment, and didn't mention a thing about any separate findings, which she had already lodged. We think that she had waived it at that point, and the context here is if you're Judge Jones and you're getting these pleadings from her and you're looking at the form of the judgment, you're looking at what she's saying as opposing any findings of fact in the judgment, I mean, he's left to believe that she has elected, as he invited her, not to have findings. As he said in his original ruling, he says if she wants them. So if it's already waived, my point would be if it's already waived to the time where she's not entitled to them, then how can she come back under 52B and seek to amend them? Because it's too late,
Well,
especially in this context.
Because the rule says she can. I mean, I agree that you can't just file a request for findings of fact and conclusions of law and never follow up on that again, and then on appeal say, the judge never made the findings that I requested under Rule 52A. I don't think you can do that, but she didn't. She renewed that request. She brought that back before the court in her motion for new trial, and the rule says that's timely. You can do it at that time. And, I mean, it's, the argument, I'll listen to Mr. Purnell, I guess we'll listen to him. The idea that it's non-waivable, I don't agree with that. I think there's lots of cases that say it's waivable. But
Judge Gould, consider this in the context of when you have to request the findings. Mm-hmm. Let's say she had never requested the findings, and Judge Jones had not issued that ruling.
right.
Could she then come back on the motion for new trial and say the findings are inadequate because she never had them?
But I think the case law is pretty clear that if it's a bench trial, you have to make the request prior to the trial. So
Right.
that's a different situation.
Right. In this case, we have an unusual context of where the findings are requested for a summary judgment motion over a year before.
I know.
So Judge Jones is going into this trial not knowing this.
I understand that,
So-
and maybe Judge Jones shouldn't have taken that extra step. I mean, I read it's page 3 of some memo, and but we're left with the fact that there's a minute entry ruling, a clear ruling by the judge that says, I will grant this as to request for findings of fact for trial. And I don't know how we can move around that.
Well, I would urge you to consider the language that he used where he says, quote, to the extent defendant wishes to have findings of fact. So is that talking about moving forward? Is that talking about if you still want them, I'll give them to you, but as we approach trial, isn't she put on the burden of then reminding the court and saying, I want findings of fact? And in fact, in this case, she lost. I mean, typically, who wants the findings of fact? I know there's case law out there that says it doesn't matter who requests it. And you have to consider the different context when findings of fact are given. One is 52 when you request it. One is by statute, and there's some case law that says, well, in certain cases you need to have findings of fact. This is one where it's requested, and if you put it in that context, I think it should be evaluated a little bit differently. I think that the burden is on the parties, through their counsel or by themselves, to bring this to the court's attention in the context of the facts that we have here.
Can I move you on because you're going to run out of time?
I am running out of time, Judge.
And let's assume we find no waiver. Why are these findings adequate? How are they adequate?
Well, I think because they deal with the essential facts of the dispute that was actually tried. Granted, they're very short, but they do deal with the essential facts. I mean, I just tried a 3-day receiver injunction hearing, and the judge had asked for findings of fact, and we submitted 55 pages of like 150 different facts. I think that's overkill. The question is, in this context, were these adequate? And we think they are, because we think they deal with the essential facts. Rule 52 doesn't give us guidance on what you have to put in the findings of fact, and the case law just says it has to be of the essential facts, the essential findings.
Do Judge Jones's 2 key paragraphs, do they address the easement issue or ingress and egress?
They don't address it directly, except to the extent that he talks about he doesn't specifically mention it, but he does talk about how she committed the default, I think is in March. And when he says that, I think that encompasses the fact that
But if she's entitled to findings with some specificity, more than he provided, isn't she entitled to know what exactly her breach was, whether the breach had anything to do with the easement, the ingress egress issues, or whether it was simply that she didn't release the property?
Well, but in paragraph 3 of the judgment, he says, Judge Jones says that as of May 25th, 2007, with the tendering of the necessary documents and monies asserted by defendants as appropriate towards the next proportional property release, defendants materially breached the commercial real estate agreement entered into the parties. I mean, beyond that, I think that encompasses an assumption that the easement was a red herring, because remember the facts, which is in the first time when they got the first release, she didn't mention it at all. In fact, we don't believe, the evidence really is, and the record is that it doesn't come up until trial. And then it's tried, and there's all kinds of evidence in the record that it was discussed as to what easements, what access was there. So I think Judge Jones found it to be a red herring, but I don't know that she's entitled to that particular finding in the context of what was in the pretrial, even though it was tried. So I am running out of time. Any other questions, Judge? I'd like to reserve
No, thank you,
my
counsel.
6:20. Thank you, Your Honor.
Okay, Mr. McGuire, I'm sorry. I called you Mr. Purnell, I'm sorry.
I bet it's happened before.
That is fine, Your Honor. I've been called worse many times. May it please the Court, my name is Purnell McGuire. I represent Kay Price in this matter. Ms. Price is here in the courtroom today, along with her daughter. Your Honor, I'll take up the first issue just briefly with respect to the waiver issue. It's obviously our position there was no waiver, and I think the Elliott versus Elliott case amply addresses that issue. I didn't mean to imply that there can never be a waiver, so let me just clarify that. There can be a waiver of your right to seek.
I think you stated in your brief that it's non-waivable, the findings of fact. I don't think that's correct. Are you telling us now that you're backing off that statement?
Let me clarify. It is waivable if you never bring a Rule 52 motion. That's what Elliott versus Elliott clearly says, is that in Elliott versus Elliott, the party participated in the drafting of the findings of fact themselves and submitted them to the court. And then after that was submitted, must have realized that it was insufficient and brought a Rule 52 post-judgment motion and then appealed. And on appeal, the court said her husband argued, well, clearly she waived it. She participated in the drafting of the findings of fact themselves. She can't now argue that they're inadequate. And the court said, no, it's a mandatory obligation on the judge's part. And while the judge can take a look at the findings that the parties submit, they have to look at them independently and determine whether or not they're sufficient. And as long as you bring that Rule 52 motion post-judgment, you haven't waived your right to then assert that on appeal. So in this particular case, my point in my briefing, and if I was not as clear as I should have been, I apologize, but I'll make clear that it's mandatory and you can't waive it so long as you bring a proper Rule 52 motion, which in this case Ms. Price did.
So she had no obligation then to remind the court about it at the time the court made its ruling or shortly thereafter?
I think the court amply established that it's a post-judgment motion. So you don't have to remind the court beforehand. Your obligation is to request it beforehand, which she did, and then her obligation is to seek relief post-judgment through a proper Rule 52 motion if she believes the findings are inadequate, which again is what Ms. Price did.
Can I ask you before you move on? Mr.
Sure.
Littler seems to suggest that Judge Jones' ruling at Record 120 necessitated some further request by your client saying, if she wishes these at trial, I'll do it. Do you read that as sort of a self-executing grant of findings of fact at trial, or do you read that as requiring something more by your client?
You know, I did look at that issue, and once you request the findings, the court doesn't have to render a ruling granting them. It is self-executing. Once you request findings, the judge has to provide them. I'm not exactly sure. No one was there back many years ago when Judge Jones rendered a ruling on this saying what he did, but the fact that she made the request is sufficient under the case law.
It's a little more amorphous than that, though, because your client never really requested findings of fact at trial. She requested findings of fact on a motion for summary judgment that was pending. And then the trial judge, recognizing that, said, I'm not going to grant that as to a motion for summary judgment, but I will take that as a request at trial. So we're sort of in this odd situation of your client's getting a new trial based on a failure to make findings of fact that she never really requested, but the court sort of construed it. You understand? This is
I think
a
I do, Your
little
Honor,
bit different than the normal case.
And I appreciate the court's argument and come prepared to necessarily address that directly because it wasn't an argument that was made by the appellant in this case. But once the court tells her that to the extent you've requested it, I'm granting it, Ms. Price is on notice that she's requested it and that they will be provided from our perspective. And again, that right was not waived. And again, to the extent that that was an issue, it was never argued in opposition to our motion for new trial down below. And I don't believe that could be brought up now. So Ms. Price represented herself pro se. There were some anomalies that happened in the trial court proceedings procedurally, but I think on this particular issue, our position is she properly requested it. The focus of the appellant's attack is that the findings are sufficient, and that I do want to take just a minute and talk about the timeliness of the motion, just in case the court has any questions about that. Rule 52 does require that the motion seeking a new trial be filed within 15 days of the entry of the judgment. We had pointed out that in this particular case, we don't even believe the judgment was final. An award of attorney's fees had not been entered yet, and there was no Rule 54B language in the judgment itself. Nevertheless, to be careful and consider it, we did file our motion for new trial, assuming that there was a judgment. Now, what happened in this case is that there was an intervening bankruptcy case that stayed the state court proceedings. Rule 362 of the Bankruptcy Code is pretty clear that if there is an action against the debtor that's been filed against the debtor, that's what happened here. MIG filed its case against Ms. Price, who then became a debtor in bankruptcy, that the matter is stayed. And then in terms of determining the applicable deadlines for taking certain action, the court needs to take a look at Section 108 of the Bankruptcy Code. And there's two sections there, 108B and 108C. And the appellant relies on 108B to argue that Ms. Price had 60 days from the time she filed bankruptcy to file her motion for new trial. That section is not applicable because Section 108C is the more specific section and applies to
Counsel, let me get you to move to a different area.
Okay.
What's wrong with these findings?
And before you answer that, I have a related question, which is reading Elliott, Miller, and a most recent excellent opinion called Stein versus Stein. Those cases make clear that the findings of fact are for our benefit, for appellate purposes, so that we can discern enough from the trial court's findings to know what its thinking was. So it's not really a protection for the parties, it's a protection for the appellate courts. So then Judge Gould's question, why aren't these adequate?
Well, I think findings serve more than just that purpose, although that is, by and large, the most important of the purposes. But there's a couple of other purposes. This was set forth in the case we cited to the court. Let me just get the citation. In the Miller case. And they said there are four purposes. One is to let's get to that. I'm sorry.
Counsel, don't worry about that. We're concerned about the purpose of the findings for our review. So
right. What's wrong with them? That's good. Well, Mr. Littler said, I wrote down a couple of notes during his argument when the court asked him about the easement issue, and he said that that Judge Jones' ruling encompasses an assumption. And if there was ever better evidence that these particular findings are insufficient, for the appellant to tell the court that they're sufficient because they encompass an assumption does not provide a way for this court to determine the process by which Judge Jones reached his decision. And that was the purpose that I was trying to get to for Judge Downey, was that one of the purposes that the court requests findings is that they permit an appellate court to examine more closely the basis on which the trial court relied in reaching the ultimate judgment. So you have to look at the basis and the process.
What's the assumption that's
the assumption,
not express in Judge Jones' ruling that he should have made express?
The assumption is that MIG fulfilled all of the conditions precedent under the promissory note.
Why is that an assumption? I thought that was fairly clear.
It is not clear
in his, even in his two somewhat brief paragraphs.
Yeah, from our perspective, Judge, it's not clear.
It's summary in nature, certainly, but doesn't it in essence say that that all the prerequisites were satisfied and the other side breached?
We could take the time to read through the ruling. From our perspective, Your Honor, that is not included within it. It is perhaps ultimately assumed that you could assume that he found that because he found that Ms. Price breached the agreement. If that were the standard, then all Judge Jones would have had to do is say, I hereby find that Ms. Price breached the contract. And then the court would have to, as the appellant argues, infer and imply all of the facts necessary to reach that conclusion. And that is not the standard. I don't know why he said or why he thought that MIG had fulfilled all the conditions preceded under this note. I don't know why he felt like they were not in default at the time they tendered the monies sufficient. We don't know why he believes that they were not obligated to provide an easement for ingress, egress, and utilities. None of that is addressed in his judgment. And I think, practically speaking, we all know why it's not in there. Because they forgot that Ms. Price had requested findings of fact and conclusions of law. And so he rendered a minute entry addressing what he thought were the issues, but he did not render separate findings of fact and conclusions of law. I agree with Mr. Littler that typically when you're submitting findings of fact, you're very detailed in submitting those. This is 2 paragraphs, and really only 1 paragraph that deals with the issues under the promissory note here. So,
In terms of the adequacy, should we ascribe any significance to Judge Trebish's conclusion that the findings were inadequate for her purposes?
in terms of
Help
the...
you?
Yes. Well, from our position, in terms of the standard review here, it's been our position that it should be abuse of discretion, and that Judge Trebish looked at this and found it very, very succinctly that the findings were inadequate, and that she could not, at that point, in speaking of the proper remedy, she could not at that point go back and review the trial transcript and make those determinations. It's procedurally unfortunate. When we went into this case, we certainly didn't know Judge Jones was going to be elevated to the Court of Appeals. And if you'll look in our motion for new trial, we had asked for appropriate relief, which would be to reopen the record and make additional findings, or if that were not possible, then a new trial. And the court looked at that and determined, because of potential credibility terminations that she felt like she would have to make, that the proper remedy was a new trial. And I think on that issue, this court should give deference to Judge Trebish and her feelings about what the proper remedy should be.
Wasn't there also a problem with the trial exhibits that your client had submitted? They were destroyed because she didn't come pick them up after trial?
I think so, Your Honor. I think so. But in terms of that was not an issue that was an issue that was argued down below. It wasn't an issue that Judge Trebish addressed.
So you don't think that also favors the remedy of a new trial versus a remand?
Well, I think from a practical matter it does. But the argument down below was that was Ms. Price's fault, and she can't create an issue that now grants her a new trial. And
Good point.
I'm sympathetic to that. But the bottom line is that those exhibits are now gone. And so Judge Trebish would not be able to review those.
If you were to capsulize the one key finding that should have been in Judge Jones' order, what was lacking? Regarding the easement, is that what you think?
That's the biggest issue, but we also believe that he should have found that MIG was not in default under the terms of the promissory note at the time they tendered the monies. And this is specifically the issue.
That's kind of unclear whether they were or they weren't. Is that what
It is totally unclear, because at page 23 of the reply brief, the appellant argues that in terms of looking at Judge Jones, the sufficiency of his rulings, they go through each one of his findings, and one was that they say the Prices agreed to release property upon satisfaction of certain terms. Okay. First of all, that wasn't one of Judge Jones' findings. That's the appellant's interpretation of his findings. So they say, okay, the judge said that the Prices had agreed to release this property upon certain terms. Then they say, in support of that statement or that summary, they quote to Judge Jones' ruling, which was, quote, through his October 10, 2006 correspondence, the defendant's attorney asserted the same calculus on behalf of his clients, the defendants, as plaintiff has insisted, is correct throughout these matters. I'm sure that didn't make any sense to you. It didn't make any sense to me in terms of establishing what terms the Prices had agreed to release the property under. It's not there. Then they go on to say, MIG met those terms and tendered the necessary documents and money. So then that's their summary of what Judge Jones ruled. And then they quote his actual statement. However, as of May 25, 2007, with the tendering of the necessary documents and monies asserted by defendants as appropriate towards the next proportional property release, they say that that language that Judge Jones quotes right there establishes that MIG met the terms that were required in order to compel Ms. Price's performance. That particular finding right there, Your Honor, to answer your question directly, is what is insufficient with the tendering of the necessary documents and monies. That statement doesn't even go to or address whether or not he's referring to the easement there, or whether or not MIG was current on the note at the time they requested. It doesn't even go to whether or not the amount of money they tendered was sufficient.
When you say MIG wasn't current on the note, is this going back to the issue that the first release of the property, the first release, they paid too little?
No, actually, Your Honor. This deals with the second release. During the course of the parties' dealings, because there was a dispute over the release, MIG stopped making payments on the note.
That's right.
Late
Okay.
charges accrued.
They did make the $500,000 payments June 2nd.
The initial payment they made.
Right.
And they tendered a second payment, which my client disputed was sufficient. They went back and forth on that issue, and then that's what the correspondence from the lawyer came in and said, $71,000 will be enough to satisfy the amount that you have to pay. But, big but, there were other things that they needed to do other than just tender the $71,000 from our perspective. Again, they needed to be current on their payments, which we dispute. They needed to tender proper easements, et cetera. So that's what that issue deals with, Your Honor. And that's why we feel like Judge Jones did not properly consider all those issues. And that was
For the purposes of Rule 52.
for the purposes of Rule 52, exactly. And that was one of the other bases for findings of fact that I just want to throw a plug in for the parties, because in the Miller case, they said one of the reasons you do findings is that the requirement prompts judges to consider issues more carefully because they are required to state not only the end result of their inquiry, but the process by which they reached it. And that's what that's our problem here, is that we understand the result that Judge Jones reached, but if he had done findings of fact and conclusions of law, we believe that he would have had to look at all of the conditions precedent that needed to be fulfilled under this note. And then we would have known how he felt about that, or he would not have ruled the way he did, quite frankly, is what I believe. Because there is no evidence in the record that establishes that they ever proffered an easement for ingress, egress, and utilities, and that's part of our cross-appeal. And I've got just a couple minutes left, so I want to throw in one issue regarding our cross-appeal here, which is the issue of undisclosed damage testimony that was offered by MIG at the trial. It's undisputed factually that damage testimony was not disclosed to Ms. Price until...
Interrupt you. If you were to prevail on the appeal by MIG, why would we spend any time on that issue? You're getting a new trial.
Well, this is where, pigs get fat and hogs get slaughtered. We'd be happy with a new
I don't
trial.
know what that means.
Gemmell probably does.
Do you know what that means?
No.
We'd be happy with a new trial, yes, but I think a new trial is in large measure unnecessary because there's no way that MIG can proffer any proof that they fulfilled the conditions precedent under this note. And with respect to the damage issue, that was just an alternative basis that we're arguing a new trial should be granted.
Start with that one. That was the worst argument on your cross appeal.
Well, I understand. Because it goes along with the new trial more than it is to grant us judgment. I don't.
And that's where pigs get fat and what?
And hogs get slaughtered. So
Okay.
let's see. I have a minute left. But on this issue regarding the easement, we did just point out in our pleadings that the way this really should have gone is that MIG should have properly pled in their complaint that they had fulfilled all of the conditions precedent under the note. Rule 9C requires a litigant to plead generally aver that this is a breach of contract action, there were conditions precedent, all the conditions precedent were fulfilled. Then it is incumbent upon the defendant to specifically deny whether that occurred. None of that happened here because MIG, for whatever reason, did not properly plead in its complaint. So its complaint, as it stands today, fails to state a claim upon which relief can be granted. in that regard. And the evidence that was adduced at trial, even though the easement issue was brought up later by Ms. Price, demonstrates that they did not present any evidence of the tendering of an easement in connection with the request for release. For these reasons, we think that Judge Trebish's ruling should be affirmed, or on the alternative, if the court finds that they could not present any evidence on the easement issue, that judgment should be rendered in favor of Ms. Price.
Right. Anything else? Thank you, counsel.
Thank you.
Mr. Littler?
Yes, Your Honor, in my 6 minutes and 20 seconds left, I first want to just address briefly your suggestion on Rule 52B. As I reread 52B in light of your comments, and obviously there's a difference in generations here between paper and technology, but I think the suggestion I would have is that if you can file a motion to amend or for additional findings, that doesn't give you leave to request it in the first instance if you've already waived it. And that would be my best argument. It's like you can't amend a complaint unless you got a complaint. And Rule 52B all talks about in terms of amendment or additional findings. And I think that's why I would suggest that it's not appropriate.
I didn't follow that.
Okay. Well, 52B says, trying to go fast and probably too fast.
Okay.
Upon motion of a party, not made later than 15 days, the court may amend its findings or make additional findings and may amend the judgment accordingly. When you talk about amending something, it has to exist. I think you're suggesting that opens the door to someone coming in a motion for new trial and requesting findings of fact when they've already been waived by not mentioning to the court, or by mentioning to the court that you said if I wanted them I could have them and I want them, or by submitting them herself at trial or near trial. My suggestion is you can't amend something if it doesn't exist. If you've already given up the right to have it, you can't amend it, and that's why I don't think it's applicable. Was that more clear, or am I still speaking gobbledygook?
No.
Counsel referred to Ms. Price being represented pro se. I just want to make a point that she obviously had some sort of assistance because she filed a number of pleadings in here, and the record is very clear. On the waiver issue, consider this, and we've been assuming in the pleadings that her failure to remind the court or to ask the court for findings at or near the date of trial was in good faith. But that may not be the case. What if somebody was keeping that concealed somehow, and they didn't tell the court that, and then tried to get a motion for new trial? In this case, 260 days later, after the entry of judgment, is when she filed the motion for new trial because of the bankruptcy issues. So I think it's important that the court consider there may be good faith reasons why she didn't do it. Maybe she forgot. But what if the party, as a policy issue, what if a party
Counsel, I don't think we're attributing any motion thoughts one way or another. I don't know if they're requesting good faith or bad faith, so I wouldn't read anything into that.
And I'm not suggesting that for these parties. I'm talking about as a matter of policy in a rule as to whether it can be waived or not. What if somebody could have intentionally tried to deceive the court by not reminding them, sort of holding a possible defense in their back pocket? And I'm not suggesting that here, but I'm talking about it when you talk about the policy of waiver and whether it can be waived in this context with what happened in this case. It's a reason why the court should consider that you don't want to leave that door open like you're suggesting in this case for her. Let's see. There was a lot of talk about the easement, and there's no doubt in the trial record that the easement was discussed at great length, and the access to the property was discussed at great length. I mean, starting at page 97 of the transcript, there was all kinds of issues that were discussed regarding the easement. Ms. Price testified that when the court asked her a question, she agreed that she refused to agree to a release because the release parcel was not contiguous and had not gotten the easements where she wanted them. I think Judge Jones had substantial evidence that this was all a ruse, because the evidence was that the easement issue was never raised for the first release, and then there was a second $500,000 payment, and that was the one that led to what should have been the second release. Then they asked for more money. MIG paid more money, and she still hadn't raised the issue of access or the release. It all came up at trial. It was all made up at a later date. The only issue at that point was whether the money was enough, and as the record shows, there was plenty of discussion of how much. There was a lawyer that Ms. Price hired to send a letter saying this is the amount. Then they wanted more, $90,000 more, and then they finally agreed, and MIG finally paid it, and then she still wouldn't release it, the property, because she didn't like it, whether it was contiguous or not. And I think that's what Judge Jones saw at trial here. Was
But, you know,
that,
counsel, I mean, by your very language that you choose, you say, I think that's what Judge Jones thought. Isn't
Right.
that the point of the findings, is to make a finding, this is what I found, right? I mean, we're guessing at that. Look, if there hadn't been a Rule 52 request,
Right.
and Judge Jones had simply entered a summary order saying, I find in favor of MIG and X amounts, that's not a problem. I issued a lot of orders like that. I suspect a lot of trial judges do. But when you get that request for findings, and then you issue an order saying, I'm going to grant that, I'm going to make findings,
Right.
it seems like, at a minimum, the judge should have made a finding about the tendering of the easement wasn't required, or what they did in terms of making a record that it wasn't landlocked, that there was an ingress and egress, satisfied Section 10 of the promissory note. I mean, that probably would have been something the judge should have done.
well, Judge Gould, as I stand before you on this appeal, I obviously would have preferred he do that. I would have preferred that Ms. Price had reminded the court that she does want the findings, because then what would have happened, and as the practice is, counsel for MIG, which wasn't me, I didn't try the case below, would have submitted them to the court, would have made sure they fulfilled all those requirements. He wasn't given that opportunity because of what she said.
I understand.
And my time is up. Thank you.
All right, thank you both, counsel. We will take this matter under advisement. We will issue a written decision in due course. Court's in recess.